Welcome to the Deep Dive, where we cut through the noise to bring you the most vital insights from the stories shaping our world. Today, we're plunging into a subject that casts, well, an enormous shadow over global commerce, and whether you realize it or not, it directly impacts your wallet: financial crime. The sheer scale is genuinely mind-boggling. The UN estimates that somewhere between $800 billion and maybe $2 trillion is laundered globally every single year.
Wow, that's up to 5% of global GDP.
Exactly. It's huge.
It's a figure that truly underscores the persistent, the enduring nature of these challenges, regardless of how much effort we seem to put into combating them.
And what's really quite worrying is that despite decades of effort, these challenges just keep morphing, keep evolving. Today, we're not just talking about abstract numbers, though. Our mission here is to take you on a deep dive into three major UK-centric corporate scandals from this century. And these aren't just, isolated incidents. They're more like fundamental pillars that have shown up these profound cracks in corporate ethics, in regulatory oversight, and crucially, in public trust.
That's absolutely right. Our goal today is really to peel back the layers of complexity in these cases. We want you to understand not just how these failures happened, but what they actually mean for you and what lessons have been learned, or perhaps, are still being learned.
Yeah.
We'll trace their historical roots, explore the specific details of each case, and then look at the ripple effects, including what's basically become this ongoing legislative arms race against corporate wrongdoing.
Okay, let's set the stage a bit. When we talk about financial crime, it's easy to think of it as a modern problem, right? And it's really as old as commerce itself.
Oh, absolutely.
You see examples going way back. Imperial China, merchants using informal systems to avoid taxes, ancient Athenians hiding assets in private banks.
The methods change, but the impulse, that drive, seems pretty timeless.
Yeah. The 20th century, though, that really transformed these sort of disparate acts into a truly systemic threat.
Right. The rise of international organized crime. That necessitated a proper, coordinated state response, which led to modern anti-money laundering, AML legislation. The U.S. Bank Secrecy Act of 1970 was a real landmark.
How so?
It essentially turned banks into, unwilling but essential allies for law enforcement. It forced them to keep records, report large cash transactions, help track the illicit money.
So we see this clear pattern, then, throughout history. Laws being born out of crisis. The BSA, as you said, initially targeted drug trafficking. Then, after 9/11, it pivoted sharply, countering terrorist financing, CTF, with the USA Patriot Act.
It's always a response, isn't it?
Seems like it.
Precisely. Each major legislative push is effectively like scar tissue from the last crisis. And in the UK, this reactive pattern was, made worse by a particularly tricky legal hurdle. The Common Law Identification Doctrine.
Okay, what's that exactly?
Well, picture this. For a company to be found criminally liable, you had to prove a very senior individual, essentially, the directing mind and will of the company, think board members, was directly involved in the crime.
Wow.
Yeah, and that principle came from a case back in 1971, Tesco Supermarkets v. Nattrass. It made prosecuting massive corporations incredibly difficult.
So, for a huge multinational, proving that a single directing mind knew or orchestrated something, that sounds incredibly difficult.
Exactly. How effectively did this shield them? Well, it created a significant legal loophole.
Right.
It made prosecuting large corporations for criminal acts almost impossible, even when the wrongdoing was, frankly, blatant and widespread.
So this legal anachronism, it gave them a shield, basically.
Pretty much. A shield of impunity, you could say. And it really set the stage for the kind of profound systemic failures we're about to dig into. It ultimately forced Parliament to act and, update the law.
And it's precisely this kind of legal loophole that allowed these massive failures to just fester for years. Let's dive into our first example, Rolls-Royce. Now, this is a company that, for many, embodies British engineering excellence.
Absolutely. Luxury, precision, national pride.
Yeah. But for over 2 decades, from 1989 right into the 2010s, there was this deeply embedded, methodical business practice within Rolls-Royce that was, anything but excellent, widespread corruption.
It's a really stark example of how a toxic culture can just fester under this veneer of respectability.
Yeah.
The misconduct wasn't just a few rogue employees. It was a global strategy, spanning at least a dozen countries.
A dozen? Like where?
Well, for instance, Indonesia. Over $2.25 million US, and even a Rolls-Royce Silver Spirit car gifted to an intermediary.
Just gifted.
To secure a contract for Trent 700 engines. Then in Thailand, between 91 and 2005, a staggering $36 million US in corrupt payments to influence engine purchases by Thai Airways.
$36 million. Incredible. So millions of dollars, places like Russia too, for a Gazprom contract. And yet, I remember reading they published a code of conduct explicitly banning bribes back in 1996.
They did.
So how does a company just so openly ignore its own stated ethics? Was that code just window dressing? A PR exercise?
It certainly looks that way, doesn't it? It strongly suggests it was.
Yeah.
And the way this finally unraveled is particularly telling. It started with a whistleblower.
Ah.
A former executive, Dick Taylor, making online posts back in 2006. This eventually led to the Serious Fraud Office, the SFO, getting alerted in 2012.
Okay, so the SFO steps in, and here's where it gets really interesting, right? Rolls-Royce launched this massive internal probe, reviewed something like 30 million documents, huge effort. But a crucial detail came out. Rolls-Royce leadership had known about corrupt conduct since at least 2010, but they decided not to tell the authorities. They stayed quiet.
And that decision really complicated the narrative of their cooperation later on, significantly. Ultimately, in 2017, it all led to a globally coordinated Deferred Prosecution Agreement, a DPA.
Okay, what does that mean exactly, a DPA?
It basically allows the company to avoid a criminal conviction, but in return, they have to meet these really strict conditions, pay a massive fine, cooperate fully, reform their practices.
And the fine was huge, wasn't it?
It was. Total penalty about $671 million. That's around $800 million US. One of the largest corporate fines in UK history, split between the UK, the US, and Brazil.
Now, Sir Brian Levison, the judge who approved this DPA, he openly questioned it. He asked, if this level of egregious criminality over decades isn't prosecuted, when would any company be?
Yeah.
Which brings us right to that critical question. In the UK, are some companies, maybe those vital to national interests, are they effectively too big to jail?
That's a tough question.
The argument was that a conviction would cause collateral damage, right? National defense, jobs, all that.
That was the argument. But if you look closer at the judgment, it actually acknowledged that only about 15% of Rolls-Royce's order book would likely have been affected by mandatory exclusion rules.
Only 15%.
Yeah. Plus, there are these self-cleaning provisions. They allow companies to avoid being barred from contracts if they show genuine reform after a conviction.
Okay.
So this suggests the too big to jail argument may be for strategically vital companies. It carries significant weight, perhaps allowing them to operate under slightly different rules.
And then there's this whole issue of cooperation and maybe a perverse incentive. The SFO gave Rolls-Royce a 50% discount on the fine for extraordinary cooperation, but that was after they got caught.
Right. Compare that to the U.S. Department of Justice. They gave a more modest 25% discount, and they specifically pointed out the failure to voluntarily disclose before being caught.
So does this mean the system might actually incentivize companies to just gamble on not getting caught? Knowing a DPA might still be an option down the line?
It definitely raises a valid question about how effective these penalties truly are in deterring future crime. And think about this. While the company accepted responsibility under the Bribery Act 2010, no senior individuals were ever prosecuted in the UK.
Nobody.
Nobody. Not for this multi-decade campaign of corruption. And that left this lingering sense of injustice, a clear accountability gap.
Wow. That's a truly powerful and, troubling point. It suggests even with these massive fines, justice can still feel incomplete. Okay, let's shift gears now. Let's move to something that really truly shook the foundations of global finance. The LIBOR scandal.
Ah, yes, LIBOR.
For decades, LIBOR, the London interbank offered rate, was arguably the most important number in global finance.
Absolutely critical.
Published daily, it was supposed to reflect the average cost for major banks to borrow from each other.
Simple idea, right?
Simple idea, but its reach was just immense. We're talking about the reference point for an estimated, $400 trillion worth of financial instruments worldwide?
400 trillion.
Everything from complex derivatives to, consumer mortgages, student loans. The integrity of this number was foundational. It was presumed to be an objective measure of financial health.
But it wasn't objective, was it? Not at all.
No.
The mechanics of manipulation, which apparently began as early as 2003, were driven by two really powerful motives. First, just simple greed. Traders at major banks, Barclays, UBS, others actively colluding with the people setting the rates, just pushing submissions up or down by a tiny amount, a few basis points, to benefit their own multi-million-dollar trading positions.
Yeah, there was this inherent conflict of interest just baked right into the system's design.
Right. And the second motive?
Fear. especially during the 2007-2009 financial crisis. Banks started lowballing their rates, submitting artificially low numbers to project this false image of financial strength and stability.
So they were basically masking how bad things really were.
Exactly. Masking the true severity of the crisis.
Right.
Trying desperately to avoid being, ostracized by the market. It wasn't just about profit then. It was about survival. But it had this really pernicious effect on the global economy.
And the global fallout from this was just pervasive.
Yeah.
Every single financial contract tied to LIBOR was potentially mispriced.
Every single one.
And this wasn't a victimless crime, was it? Consumers with variable rate mortgages might have paid more. Local governments, particularly in the U.S., lost at least $6 billion.
Yeah, billions.
But maybe the most damaging thing was the erosion of public trust. I mean, coming right after the 2008 crash, this scandal just confirmed everyone's worst suspicions. The system was rigged.
Operated by a cartel.
Yeah. And those brazen chat logs between traders that came out, that really cemented the divide between Wall Street and Main Street, didn't it?
It absolutely did. The regulatory reckoning was pretty sweeping. Over $9 billion in fines levied against the big banks, Barclays, UBS, Deutsche Bank.
And individuals went to jail.
Yes, individual traders like Tom Hayes were criminally prosecuted and imprisoned. But the most significant legacy, really, was the recognition that LIBOR itself was broken. Just fundamentally flawed, beyond repair.
Why was it so flawed?
Well, it was administered by a private trade association, the British Bankers Association. And critically, it relied on unverifiable estimates from the banks themselves, especially when the actual interbank lending market froze up during the crisis. That just created fertile ground for manipulation.
So a system built entirely on trust just utterly crumbled.
Completely.
So what happened then?
Well, the UK's Financial Services Act, 2012, criminalized benchmark manipulation. And then this monumental, decade-long global effort began to transition away from LIBOR.
Towards what?
Towards new, more robust, risk-free rates. Things like SONIA here in the UK, SOFR in the US. These are based on actual market transactions, not estimates.
Okay, that makes sense.
The final LIBOR rates were published just last year, actually, end of September 2024, marking a definitive admission, really, that self-regulation in this area had failed.
It's a fascinating admission, isn't it? A whole global benchmark just killed off.
It is. And what's crucial to remember here, I think, is that despite those massive fines on the banks, individual victims found it almost impossible to prove direct harm in court.
Really? Why?
Just incredibly difficult to quantify the exact loss caused by a manipulated rate on your specific mortgage or loan. So this justice gap where the institutions paid but individuals really struggled to get personal redress, that just reinforced public cynicism even further.
Okay, our third and final case study today is, I think in many ways, the most devastating because it strikes so close to home for ordinary people, the Post Office Horizon scandal.
Yes, this one is different.
This isn't just corporate malfeasance, it feels like a profound, almost cruel betrayal of trust by a state-owned institution against its own citizens.
That's a good way to put it.
It all started with the rollout of the Horizon IT system made by Fujitsu back in 1999. And almost immediately, it was apparently plagued by bugs, errors, and defects.
Right from the start. And this technological failure was then compounded by this uniquely punitive contractual arrangement.
What was that?
The sub-postmasters, you see, they were independent business people running local post offices. But their contract held them personally liable for any shortfalls the Horizon system showed in their accounts, even if those shortfalls were just phantom numbers generated by the faulty software.
Personal liable, so the system makes a mistake and they have to pay it back out of their own pocket.
Exactly, which created this huge perverse incentive for the post office to just ignore the mounting evidence of flaws, to protect its own system, its own perceived infallibility.
It just sounds like a catastrophic failure of governance.
It absolutely was. The post office acted as the alleged victim, the sole investigator, and the private prosecutor, all in his own cause.
The human cost is just almost unimaginable. Between 1999 and 2015, over 900 wrongful prosecutions.
900.
Leading to more than 700 convictions for dishonesty, theft, fraud, innocent people sent to prison.
Heartbreaking stories.
Seema Misra, a pregnant mother of two, jailed on her son's 10th birthday, accused of stealing £74,000.
Terrible.
Martin Griffiths, a father of two, took his own life after being falsely accused of stealing £61,000.
And there were others. Financial ruin, bankruptcy, lost homes, public shaming, family breakdowns, severe mental and physical health crises. At least 13 known suicides linked to this. It's just utterly devastating.
How did this go on for so long? How did nobody stop it?
Well, the long road to justice was really spearheaded by one man initially, Alan Bates. His own contract was terminated, and he formed the Justice for Sub-Postmasters Alliance back in 2009.
So they were fighting back early on.
They were, but the post office repeatedly insisted Horizon was robust. They actively suppressed internal knowledge of the flaws. The then CEO, Paula Venables, famously told Parliament in 2015 that there were no miscarriages of justice related to Horizon.
Unbelievable denial. Infuriating.
It really is.
Yeah.
The turning point finally came in 2017 with a group litigation order, a GLO, led by Bates. And then in December 2019, Mr. Justice Frazier delivered this landmark High Court judgment. He ruled Horizon was not remotely robust and had numerous bugs, errors, and defects.
That ruling must have just shattered 2 decades of institutional denial.
It absolutely did. The aftermath has been profound. There's a public inquiry still ongoing. That ITV drama, Mr. Bates versus the Post Office, earlier this year, really galvanized public outrage.
Yes, that really brought it home for so many people.
It did, and it forced unprecedented legislative action. The Post Office Horizon System Offenses Act 2024 was passed. It uniquely quashed hundreds of those wrongful convictions en masse.
An act of parliament to overturn convictions, that's extraordinary.
It is. What this whole saga highlights, I think, is a case of institutional gaslighting on a massive scale, where a powerful organization used the perceived infallibility of technology to deny the victim's own reality. It was just a complete failure of every single institutional safeguard you can think of. Governance, oversight, the justice system itself. Everything failed.
So what does this all mean then when we connect these 3, frankly, incredibly disturbing cases? What's the bigger picture? The cumulative impact on public confidence is just undeniable, isn't it? These scandals seem to have attacked public trust on 3 different fronts.
I think that's right.
Rolls-Royce eroded faith in corporate Britain, showed even our national champions could harbor decades of corruption. LIBOR shattered trust in the city, in the global financial system itself, revealed manipulation of fundamental economic metrics.
Right, the very numbers we rely on.
And then the post office. Perhaps most damagingly, it destroyed trust in the state itself, showing a government-owned institution could persecute its own citizens with such devastating consequences.
When you put all 3 together.
Yeah.
Yeah, it really created what you could call a perfect storm of cynicism.
And the economic harm goes way beyond just the fines, doesn't it?
Oh, definitely.
We're talking billions in direct costs, over $1 billion expected just for post office compensation alone.
And that's probably still not enough.
Probably not. But the indirect costs are massive too. Illicit financial flows, IFFs, draining resources from economies, eroding tax bases, distorting markets, discouraging investment.
Absolutely.
Yeah.
LIBOR distorted asset prices globally.
Yeah.
Rolls-Royce's actions undermined the rule of law in other nations it dealt with. The ripple effects are huge.
So if we look at the broader picture, we see that reactive legislative cycle again, don't we? In action once more.
We do. Rolls-Royce exposed the challenges implying the Bribery Act 2010, which kind of solidified the use of DPAs as a tool.
Right.
LIBOR directly led to the Financial Services Act 2012, criminalizing benchmark manipulation. And the Post Office prompted that unprecedented Post Office Offenses Act 2024.
So individual responses.
Yes, but they sort of culminate in broader legislation, like the Economic Crime and Corporate Transparency Act 2023. That introduces this new failure to prevent fraud offense. That's the real legislative scar tissue from these and other failures.
Okay, so looking ahead then, how do we finally get ahead of this? How do we actually prevent the next scandal?
That's the million-dollar question, isn't it? Or perhaps billion-dollar now.
Yeah, probably. The enforcement landscape is certainly changing. The SFO has this ambitious 5-year strategy aiming to be more proactive, using tech and intelligence to spot threats earlier. And that Economic Crime Act 2023 you mentioned, with its failure to prevent fraud offense that kicks in September 2025, right? That sounds like a huge deal.
It really is. It shifts the burden of proof. It forces larger companies to prove they had reasonable procedures in place to prevent fraud happening, not just react to it.
So they have to be proactive now.
Exactly. It forces major overhauls in corporate compliance programs.
But it's not just legislation, is it? There's a technological arms race, too.
Absolutely. The legislative arms race has this parallel technological front. On one side, you've got criminals getting smarter, exploiting crypto mixers, sophisticated AI deepfakes to hide their tracks.
Scary stuff.
It is. But on the other side, financial institutions are deploying their own advanced weaponry. using AI and machine learning to monitor millions of transactions, identify complex patterns, reduce those annoying false positives. It's a constant battle of innovation.
That sounds positive, but it does raise that important question for all of us, for you listening. How do we balance security, economic competitiveness, and individual privacy rights as this surveillance gets more pervasive, more intrusive?
It's a genuine trilemma, a really difficult balancing act we're all navigating.
And beyond the tech, strengthening the human defenses must be critical too.
Oh, absolutely critical. The post office scandal is the ultimate reminder, isn't it? That even the most sophisticated systems are only as reliable as the people and the governance structures overseeing them.
So things like corporate governance codes.
Yes. Revisions to the UK Corporate Governance Code this year, for example, they really emphasize board responsibility for robust risk management and fostering a culture of integrity from the very top, moving away from just tick box compliance.
Trying to make it real, not just paperwork.
Exactly.
And crucially, whistleblowers, they're so often the first and only line of defense, aren't they?
Often, yes. But the UK's main law here, the Public Interest Disclosure Act from way back in 1998, it's widely seen as outdated and inadequate.
So what's needed?
We arguably need significant reform, maybe even a dedicated Office of the Whistleblower, and stronger incentives, not just protections, for people to bravely speak up when they see wrongdoing, making it easier, safer, and maybe even rewarding.
So wrapping this all up, what does this mean for you, the listener? Well, scandals like Rolls-Royce, LIBOR, the post office, they aren't inevitable acts of nature.
No, they are the direct product of failures. Failures in culture, in oversight, and in accountability.
And as an informed citizen, as a consumer, your role in demanding transparency and integrity from the institutions you deal with is absolutely crucial.
Absolutely. You have to be aware of how these systems work and, critically, where they can break down.
So preventing the next wave of scandals really depends on a collective commitment to transparency and maybe a renewed focus on placing, enduring human values ahead of either the blind pursuit of profit or maybe an unquestioning faith in a machine.
Well said. So we'll leave you with this thought. What are you going to look for in the institutions you choose to trust?